policy at the federal level are watching us. I think they're watching us from the state as well. And how we respond to this challenge of building infrastructure is going to be noticed. And that is something that we have taken on. We took it on 2 years ago when we first initiated a zoning change to address wireless infrastructure. We've grappled with it for several years now. And you know, we do have the mantle of leadership here. I know that many people are seeking amendments that would effectively prohibit service. There's no question about that. Many people do not support 5G. They do not want it to come to their communities, and they are seeking that we pass amendments that would prohibit service. Personally, I do not think that is the right way to go, and I do not think that, as Councilmember Leventhal explained last time, you know, in different words, we can't stop the world from turning. 5G is coming, but I also think that the benefits that we've all gained from wireless technology have had a huge impact on our lives, and there's no question there's challenges with that, but there's a lot of benefits, and I think our residents expect us to embrace the future and move towards that future, and there's no question that wireless communications is our future. So by passing an ordinance, I think we best shape our own destiny. I think we are identifying, I think the draft has protections that are reasonable, that will survive challenge, and we will see about the amendments that are proposed and whether they can meet that test. But I certainly urge my colleagues to move forward and support this zoning change so that we can move on and fulfill something that I think our residents expect. You know, when they turn on the tap, the water flows. When they flick the switch, the lights come on. When they turn on their phones, they expect to get a signal. And today, maybe they can, but where will they be in 5 years? Where will they be in 10 years? I think that's what this vote is about today. Mr. Zients, can you, anything you can do to to shape this up, but we'll move directly to amendments, I think.
Right. Of course, what's before the council is the Fed recommendation for approval. There were some amendments in the Fed recommendation. What my memo tried to do, though, was to capture the amendments that I had been informed that council members would make. I am now informed that Councilmember Hucker has a slightly different amendment that he'll pass out. Councilmember Hucker's amendments would make all poles a conditional use, would require a 40-foot setback, and would add some land uses to the list of where a pole is prohibited. It would include educational institutions, religious facilities, parks, daycare centers. I think I got them all in my head. But to functionally do that amendment would require a significant change to the ZTA. He has a copy of that with what he's going to hand it out, and I think you might wish to take that first.
Very good. So, Mr. Huckers, do you have, are your amendments in the packet? I understand there may be a revised version. Okay. I think not all of us may have received it. Is that coming around now? Okay.
Yeah. Not substantially different than what Mr. Zients had emailed out.
Okay.
Just correct it.
Would you like to?
Do you want me to
Yeah. Would you like to describe?
speak
your
to the first
amendments?
one, please?
Sure.
Right? Okay. Thank you, Council President. As amended, the ZTA before us creates a two-tier system, and I have an issue with that. The residents with underground utilities are allowed to appeal under the conditional use process. Residents with overhead utilities, many of our older communities have no ability to raise their concerns before a hearing examiner. because attachments are allowed under limited use in those cases. They're just out of luck. So this ZTA sets up two separate and unequal systems. Some people will have a right to redress, some people won't. I don't feel like I can explain to my constituents why under this ZTA some of them are winners, some of them are losers, and I'm concerned that while a lot of people are concerned about this issue now, it's only a tiny fraction of a very large county learning about a very new industry that has yet to expand across the county, and that community concern is only going to increase as more antennas start popping up around the county. So I think we have not just an opportunity but a responsibility to really get this right. The previous comments about this ZTA being about service or no service or the future or no future really, to me, aren't accurate. I think they're sort of a red herring. We have plenty of time to get this right and to meet our responsibility to reduce the community concern about this. So I believe at core, the First Amendment here is proposed to treat everybody the same way. It's the right thing to do. It's the only justifiable approach, I believe, going forward. So the First Amendment requires, as Mr. Zion said, applicants in all residential zones of the county are subject to the conditional use process. I'll be here at least another 4 years and in the community much longer. I want to be able to look back. I think you all probably agree, and explain that we treated everybody fairly. We gave them all the same right to redress and the same right in front of a hearing examiner. So with that, I move the amendment.
I'll second it. Which, the First Amendment?
The First Amendment.
Okay. So the amendment's been moved and seconded. Let's, again, Mr. Zients, can you just describe the amendment,
Excuse me,
please?
is this what's in, all the stuff that's in his memo?
There is
So
a
is it-
memorandum that we have in front of us that says to County Council from Councilmember Hucker.
So it's
Under number
several.
one.
Oh, just number
It's
one?
number one.
Number one.
Well, number one has 3 bullets. Is that what you mean?
Yes.
Okay.
Two
Deletes
bullets.
the limited use towers added by ZTA 1811, retains the 60-foot setback, but allows the setback down to 40 feet only if necessary to avoid a denial of service claim, which is language I think our staff's comfortable with. So as it says, line 231 changes from 10 to 40 feet, line 326 changes from 60 to 40 feet.
So let's
That's the
get
amendment.
some staff. We have questions. I think we will now have questions on this item. Let's start with, I'd like to ask the executive branch and council staff to comment on this, please.
Thank you. This is Joy Nurmi, Special Assistant to County Executive Ike Leggett. Mr. Leggett does not support these amendments. He believes that they have the effect of prohibiting service and that they would not be legal under federal law.
right.
He has tried to strike a balance where, let me just speak to the two-tiered system. I think we've spoken to it several times, but just to remind everybody, the reason that we went to a conditional use for the smaller poles is because they're typically limited to neighborhoods where there are these very small 14-foot poles. In other areas where you would have a limited use, you have either the large Cobra streetlights that are located mostly along our major highways, or on utility poles where there's a lot of equipment already existing in neighborhoods. And that was the reason for the two-tiered system, because it was considered that there are already.
It's treating technologies equally, right? There's some requirements about that. Mitzi
And
can-
that too, Mitzi can speak to that.
And I
Mitsuko
can as
Herrera
well.
from the Department of Technology Services. I want to add to what Joy has said in this, the two-tier, which I think is more aptly described between the tall and the short poles. The other reason for doing it is that the county has had for 15, 20 years a policy of incentivizing deployment through limited use. It gives you a reason to co-locate, put things on existing buildings, rather than come in for new structures. So to deal with small cells, what we said is where you have these taller streetlights, where adding equipment to them will be less obtrusive, you give the providers an incentive to look for as many of those as possible and deploy their equipment, which works sort of, they work in connection to each other. So you can design it in a way that I can get on the most poles that are limited use, and I can avoid having to go to the residential neighborhoods. If everything is treated the same, there's no incentive to go and deploy things on the larger road. You may as well just go for the one that you wanted that was smack dab in the cul-de-sac, because the cost and time and effort to get there are going to be the same, and I might as well deploy it where I get the most bang for the buck from where I've deployed it, as opposed to trying to find a way to put them outside of these neighborhoods with the shorter poles, put them on wider streets. So that's why the executive, in looking to go towards that system, looked to do that. And the
Okay.
executive supports the amendments, not to get too far ahead, but supported the concept that as part of that limited use, the provider will have to come in and say, tell me why you couldn't use something that was 60 foot. If you can use the 60 foot, you're done. You can use the one that's 60 foot away. If you can't find one that's 60 foot away, then tell me why you couldn't and provide that information. And again, it means that the provider is going to come in and look for a limited use on the taller pole.
Drucker, would you like to?
Yes, the issue, two things. I don't think it's accurate to say that the way the ZTA was constructed restricts, incentivizes to attach antennas to these taller Cobra poles that are widespread. They are not widespread at all. I know Silver Spring quite well, and it's my impression, and many of our older communities across Chevy Chase and Bethesda. I have a constituent here who fought for months to get one single Cobra light on Flower Avenue attached to address a pedestrian safety concern. I have another one several blocks from my house that had to fight for months with me to get one single Cobra on Franklin Avenue. There are not many big Cobra poles in downtown in all the neighborhoods inside the Beltway in Silver Spring. There are lots of individual poles that are allowed for limited use in front of people's houses, all up and down, both neighborhood streets and minor arterials. And those are all fair game under the ZTA as proposed now for antennas. And that has created a lot of concern. So if we can make those conditional, I believe we should. On the issue of discrimination, which was raised 2 weeks ago, I know we were told that when I proposed this conceptually 2 weeks ago, it would not be allowed under federal law because we have to treat all wired, telecom, and cable and wireless industry the same. In fact, that's not true. I will refer you to the 3-page memo from Mark Del Bianco, who is a U.S. Department of Justice attorney for many years, and then an industry attorney with Skadden Arps and many industry clients for years, who makes clear in the memo why what the federal law requires is you cannot pick winners within and discriminate among wired providers. You cannot treat wireless providers differently than each other, but you can treat wired and wireless industry differently under federal law because they are functionally different industries. And the verification for Mr. Del Bianco's memo, I asked that question to the top counsel for the utility subcommittee of the House Economic Matters Committee yesterday, and he agreed that was right. He says you're a home rule county. You have broad authority under state code in the land use article and the local government article. And you can do anything you want on utility poles as long as you don't run afoul of state or county law. State law doesn't regulate utility poles at all in the right-of-way. And the proof that the state obviously isn't running afoul of federal law is the fact that they treat wired and wireless industries completely differently. They have a vigorous regulation system for wired utilities, both telecom and cable, and they have no regulation of wireless utilities. The state is not afoul of federal law, and we would not be afoul of federal law if we treat them differently. And third, I spoke to staff at the PSC, who I was referred to by the House Economic Matters Committee. They said exactly the same thing. And they said, as a matter of context, that they have been dealing with these questions from local government officials and staff all year, and that industry lobbyists, advocates, as is their job, have been going to local governments all over the state and waving around the FCC order and saying, see, this says in this very esoteric area of law that most people don't understand, that you just have to comply with what we want. And you have to allow antennas wherever we want them. And the expert at the PSC says he's been rebutting those claims all year from local government staff. Thank you.
All right, Mr. Hooker?
If-
Oh, Jeff, please.
Just a couple of things. Number one, as a matter of policy, it depends whether the council does want to be more welcoming than not. To make this a conditional use puts burdens on the applicants, burdens on the residents, burdens on staff. So it depends what process you want. And within the process of conditional use, by its very nature, it's deemed to be compatible within the zone to start with. The only reason you would deny a conditional use if it's at a particular location, it had particular adverse effects. Now, traditionally, that has been something like more traffic at one location, safety concerns for turning movements, some other land use that it's inhibiting. This would be very unusual for the hearing examiner on the basis of compatibility to say that a utility pole, which lines the streets, but is 10 foot taller at one location, is incompatible with the rest of the neighborhood. That seems like an odd determination to make. If this is not to be a prohibit service, then the vast majority, like 90%, you're going to have to, we're going to have to approve as a county, because otherwise there will not be the penetration into a neighborhood that is needed to enhance this service. So that's a little bit both policy and operational. There is one thing in the FCC order that speaks to general infrastructure, not just wired or wireless. It generally says that if for the purpose of something like aesthetics, you don't have the same controls on other infrastructure, then it's inappropriate to have on wireless communication. Now, I am not the expert that Mr. Hucker consulted. In the words of Tony the Tiger, the FCC ruling gives me great pause. But I know, terrible.
Just got that, yeah.
But the one other thing in there is the 40-foot setback, and at 40 feet, it may work. That we have 75,000 poles and light structures in the county. At 40, the difference between a 40-foot setback and a 30-foot setback is about 10,500 poles or something like that. It depends how they're distributed. If in fact there's an entire neighborhood that has that doesn't allow a 40-foot setback, that too may be a denial of service.
Okay, that's helpful.
Can I ask a question to follow up? I guess, Mr. Zients, I would point out I understand what you're saying about the hearing examiner. The hearing examiner would be allowed to consider the criteria that the council allows under county policy within our authority. So, that's one thing now, and it could change in the future. Where is the 90% figure come from?
I mean, that's a rough guess.
Is that a guess?
In my,
I thought so.
Wagner method.
You have to approve the applications or you're denying service, Mr. Hucker.
Right. The question is how many and in what places?
Again,
Actually, the question may not be that, because there's a shot clock and there are tremendous federal supports behind the applications.
Can I speak to the law?
Yes, please.
Okay. We're not talking about the FCC orders now. Now we're talking about federal law, which is removal of barriers to entry, which I just pinched it and lost it. And it has to do with the fact that you can't prohibit you can't have the effect of prohibiting service, and that's completely different than what Mr. Hucker
You
is
may not- we-
talking about.
I think we all agree, there's no one disputes that we are not allowed to deny service.
47 U.S. Code, Section 253,
So-
removals of barriers to entry.
Understood.
It's different
we
than
all
the
agree with that.
FCC order.
Understood. The question is what the courts will find. And at least two courts have recognized, if you refer to Mr. Del Bianco's memo, two recent court decisions have recognized that a locality does not violate Section 253A by enacting procedural requirements for wireless facilities, including small cell, that are different from or stricter than those that apply to companies providing other services. That's exactly what the PSC told me yesterday, that they view the federal requirements as a floor, and a locality can build stronger procedural requirements or setback requirements on
Right.
top of the federal
Which we would
requirements.
rely upon for the ZTA as introduced.
Right.
Yes, if I could to speak to that point. One is, we do impose additional requirements on wireless deployments through both the telecom, the tower committee, the transmission facilities coordinating group, and the submission of additional information, and we impose additional conditions regarding setback and height restrictions. To the memo that Councilmember Hucker is speaking to, I think it adopts a rosier picture of the law, and in the FCC order, they went out of their way repeatedly to pick the couple circuits that ruled in their favor and to say that we are specifically overturning the circuits that didn't rule in our favor. So whether or not that particular case will stand up, it's in a different circuit than we are. I will tell you that as part of our appeal of the FCC order, there were appeals filed in the Ninth Circuit within the 10-day window for the lottery in order to take advantage of that. But I cannot say that those are going to stand up. And frankly, we have challenged the FCC on two different occasions, specifically on the wireless, and in both times we've lost those cases, and I think we had, frankly, a pretty reasonable argument. So you can't predict what's going to happen on some of these cases, but
Understood.
but the argument that is going to be made is going to say that we have a need to provide service, and we have a need to deploy a lot more poles than we have today. And the reason we set the ZTA up in a two-tiered system between the taller and the smaller ones is that it allowed us to efficiently move through ones that would have the least impact and to reserve and be able to defend our ability to have the conditional use for the ones that have the most impact.
Okay, Mr. Berliner, sorry, you're done, yeah. On this item.
Thank you. I have great sympathy for this amendment. Had conversations, Mr. Zions was present, with our county attorneys with respect to this, and raised this issue long before Mr. Hucker put forward the amendment as to whether or not we needed limited use and conditional use, or whether we could have everything be conditional use. And I was told in that meeting with our county attorneys in no uncertain terms that that would be unlawful. Okay? If there is a different view now, Mr. Hucker has shared with us a legal opinion that says the opposite. What I need to understand is, why does conditional use in and of itself make it unlawful? I get that it's a burden. I get that. I'm sorry, the industry can contribute to the cost with respect to this. If we need to staff up, we can staff up with respect to this. We have a shot clock, we'd have to meet the shot clock. No question about that.
Streamline the process.
And our community that I represent, Mr. Hucker alluded to, Bethesda, Chevy Chase, those communities, I hear from my peeps. They are saying, I want the same protections as a matter of due process. Not necessarily because it will change the outcome. Mr. Zions has suggested that we're going to have to improve 90%. That may or may not be the case. But then citizens have rights. So I need to understand why giving citizens rights in a context in which we must meet the shot clock is preempted by federal law. Because if this is a matter of policy, we're in a whole different conversation. If this is a matter of law, as someone who is proud of my practice of the law, I'm in a different place. So I need to understand exactly why conditional use in and of itself, where we hire more administrative law judges, where we honor the 120 shot clock, where we do what we have to do in order to process these applications in a time frame that is appropriate. Why is that preempted as a matter of law? And I have to say, Ms. Nurmi, on several occasions now, you've been here before us, and we haven't had the county attorney here. I don't understand how we can be having these conversations without the county attorney here. We have Mr. Zions, whose opinion I respect and who I want to hear on this question. But I would ask you to get Mr. Hanson and Mr. Royalty over here. Mr. Zions?
A complicated question.
Actually, not so much.
Not so much. I think on it. No.
That was the
Hello,
fastest.
Joy, you did a great job.
Thank you. I'll defer to Cliff.
Okay. You get it on response time. We'll see on responsiveness. Mr. Zions, why is it, as a matter of law, conditional use preempted? Meeting the shot clock.
Right. Depending upon the interpretation of the federal order, under current law, I don't know that it is preempted, so provided the results of it do not preempt service.
Right.
And that will always be the test, as opposed to the test that we generally use with conditional use, which is it more adverse here than there? And it's only under a conditional use where it's more particularly adverse that you can deny. Now, if that denial, again, will result in the need for approval somewhere else in that area, if it's because of the coverage conditions that antennas meets. But as an absolute, if you meet the shot clock, if the results are not a denial of service, if your fees are reasonable, not in terms of what the real costs are, but reasonable in terms of the FCC saying that $270 an application is a reasonable fee, whereas our $100 for a fee, whereas our fees for conditional use right now are $16,000 per pole. If you change your fees, if you expand your service, if you're able to meet the shot clock and the result doesn't preempt service or prevent service, you could do it.
So from my perspective, this is about process. This is not about the result. The result has to be what the result is. But it is, the question that has been posed by this is whether or not all of our citizens should be given the same rights with respect to due process. Mr. Royalty, you've been working this issue for a long time. I have great respect for you. I've worked with you for many years.
Thank you.
Tell me whether, maybe I should have deferred that until I got your answer.
Should have heard my answer first.
Yeah.
Look, I concur with what Mr. Zions just said. It's the
So
simplest
on
way to
its
put it.
face, providing conditional use is not something that is preempted by federal law. Only the results.
Well, our process would need to be streamlined. We need to meet the shot
Right,
clock. The
right.
cost would have to be far lower. You might need to hire a team of hearing examiners.
Exactly.
There are costs associated with that, but if you did all of those things,
Yes.
yes, you could potentially have a conditional use process that would survive federal scrutiny.
Thank you. Let me turn to the second part of this amendment, which is the 40-foot amendment. I have language that that Mr. Hucker is effectively amending that goes from 30 feet, if you will, to 40 feet. Let's talk about 40 feet and whether or not 40 feet is doable. And it's a separate, totally separate issue. So
Right.
let's talk about the 40 feet.
And let's talk about it first, in the fact that it's really not overriding one of your amendments, because your amendment dealt with limited uses. Mr. Hucker's amendment would completely eliminate limited uses in residential areas, so
Fair enough.
it would go away.
Right. But the basic construct had been 60 feet down to 30 feet if they proved that they needed it. And I assume that that was true, I apologize, in conditional use as well as limited use. But that would be the essence
Right.
of what I understood, is that what we were trying to do is saying, we want 60 feet. If you prove that you can't do 60 feet and can do, and must do something less, okay. But we had set it at 30 feet was the limit, and now Mr. Hucker is proposing 40 feet.
Right.
Talk about 40 feet and what the impact of that is and whether or not that is a denial of service on its face. And if it's not,
Again, it's not on its face, because you have to know how it plays out in geography, and whether that there are some opportunity to provide that pole and meet that setback. And I have statistics. It's hard to go through the maps with you, although it is mapped out. It looks to me, number one, out of the 75,000 or so poles and streetlights that we have in the county, the number of poles that are greater than 30 feet but less than 40 feet is about 10,500. So I didn't work out the percentage. It's something like, is that near 20% to 14? It's less than 20%.
That would be in addition to the 15,000 that we have that are less than 30.
Yeah, right.
So there's 15,000 of them are less than, so there's, you have the sheet there? Okay, so in the residential areas only, what you're talking about, I think, are 60,000 poles. Of those, 5,300 of them are less than 30 feet. And there's an additional 10,000 that are less than 40 feet. And that would leave you with roughly a remaining 40-something.
so
the
thank you
40
for the
feet.
math. I don't know how that translates.
Well, okay, so that's what Jeff pointed out, is that so what matters is, and this is what was hard when we looked at those numbers, right?
It sounds
So-
like there are a lot of poles left.
And what's, well, no, but hold on, we're talking about two different things. The question was asked about the 40-foot. If we change the 30 to the 40-foot.
If we do,
In many areas, there will still be poles that can be used. There may be, in some cases, poles that could not be used.
yes. And would service be denied in that entire neighborhood as a function of that?
There are
would we?
some neighborhoods where it would be very difficult to find something. There are some neighborhoods where
Yes.
you could find them.
And so is there, what I don't understand from Mr. Hucker's language is, if it would result in a denial of service for an entire neighborhood at 40 feet, is there a basis to then say, okay, at that, therefore go to 30 feet, or is it, we're done here?
Not as drafted.
Not as drafted, but,
Contingency?
I'm just trying to
offer
understand,
that.
I'm
Okay,
trying
but
to
in-
understand what the impact is.
okay, but in looking at the way that conditional and limited use work, if you said, taking Mr. Berliner's amendment and said, and Mr. Hucker's changed to that, and you said, if you come in for limited use, you can meet the 60-foot setback, you get the limited,
No, you're coming-
If
coming
I were
in for
you, I'd
conditional
stay
use.
with conditional use conversation right now,
okay.
just for purpose of this
So
conversation.
in the conditional use, if you changed it so that the minimum would be you could not get below 40 under any circumstances, then you'd have no way within the conditional use process for the hearing examiner to help you find something that helps you not deny service. Because you've taken away the discretion to address those difficult neighborhoods.
If you make that the standard, that the general standard is 60, you can go down to 40 if necessary. You could not, under those conditions as drafted, then go down to 30.
That I understand. And so
So-
what I'm trying to understand is, at 40 feet, are we denying service?
The likelihood is higher than it was before,
Is that what
that
is
it
your?
may be a denial of service.
So if Mr. Hugger would be willing
Sure.
to consider that as part of your amendment, I think that would make it easier in the instance in which it would result in a denial of service,
The two-tier approach?
a two-tiered approach.
So it would, if I understand this correctly, it would still read 60 to 40. However, if 40 results in a denial, well, why would you ever go to 40?
That's what I'm saying, so why just make it 30?
I mean,
You might be able to-
it would just be making it 30.
Presumably because you could establish in the hearing that you had service at 40 and you didn't need to go closer. But
But the hearing examiner
Oh,
can look
I
at
see.
that without,
I
the
don't think
hearing
we're gonna
examiner
look at-
can look at that without that being, having to change that. The hearing examiner can look for the ones that are farthest without having to have that additional 40 in there. The other thing I would also note is that the hearing examiner is looking to see what is the least visually obtrusive. There can be locations in which a pole is farthest from a house, but it sits in plain view, not shrouded by any trees or anything else, and it's actually more visually obtrusive even though it's farther from a house.
you have hearing exams. Yeah. Yeah, right.
Right.
Can you clarify, has there been
Roger's
any
making a
adjustment?
friendly amendment.
Roger's made a friendly amendment, which would be, what again? That you would say 40-foot setback, but it's still conditional use?
So I am amending or suggesting, I'm in conversation, okay? I'm doing this in real time like everybody else, all right? And so what I was trying to ensure is that, A, if we go to conditional use, which eliminates a limited use completely, that the process we envision says the marker is 60 feet, if we can, down to 40 feet wherever possible, and only where required to provide service would we go to 30 feet. That's what I was,
So it's conditional use everywhere.
With additional
But
flexibility for the hearing exam.
It's up to 30 feet if necessary to provide service.
Yes.
yes,
So, okay.
40 feet preferred. Where-
I don't know if there is, well, anyway, okay. You've said what you said.
I said
don't
what I
know
said.
what it-
I mean, the language could say the hearing examiner shall.
All right, so discussion on this amendment. Mr. Rice.
Thank you very much, Mr. President. So this has been an interesting discussion. I did just want to start with one of the premises that my colleague, who I have great respect for, said at the beginning, which was winners and losers. You know, that cuts both ways. Folks who don't have service now consider themselves great losers. Those who have homes with businesses in them and want to have connectivity consider themselves big losers. So let's be very clear about pitting folks against each other. They're all residents. They all have concerns. Let's not pit them as winners and losers. Let's talk about how we can find compromise. So moving forward, I think that the process of incentivizing, as you said, Mitzi, them to utilize taller poles is something that certainly makes a lot of sense. It's my hope that if we do move forward with this conditional use process, that as the majority of companies here in Montgomery County are partners with us in trying to put forth the best way in which we can roll out quality access to service, as well as not impacting our communities negatively, they'll still look at that and still use that as a lead. I do agree that it's important to incentivize our companies, but at the same time, I do feel as though they oftentimes make decisions that are in the best interests of our community as well. And so by having the conditional use, it's something that, again, while I understand the incentive isn't explicitly stated, would still, we could hope that they would continue to look at it positively. I'm just going to comment on Councilmember Berliner's amendment to Councilmember Hucker's amendment at this point. I think that the 30-foot makes a lot more sense. I was prepared to support Councilmember Berliner's amendment for 30 feet for limited use. And so from that perspective, I don't think we need to have confusion in the system of saying 40 and then 30. If it's going to be 30, it should just be 30. So that's just my take in terms of where that goes. My biggest concern lies with impact on us. We've talked so much about the cell phone companies and the burden on the cell phone companies. We've talked about what our constituency and whether they'd like to see towers or not, and so the service aspect, but we haven't talked about government and government operations. And so I'm very curious, as we talk about ramping up a huge number of potential conditional uses, what that might mean for the planning board, what that might mean for DPS, what that might mean for our hearing examiner. We just came off of a conversation where we were talking about reducing fire service. And so from a monetary perspective, it would be irresponsible of me to not ask, what are the fiscal implications of doing something like this? So let's just go down the line. I'll start with you, Mr. Russ.
Point of information, Mr. President. Before we assess fiscal implications, you need to determine the baseline. So if you're doing a cost estimate, you need to figure out whether the cost estimate is against current law, which requires a conditional use, or against the bill as reported by the Fed committee. So let's just be clear about that, right? What are you asking for? Because right now, conditional use is the law. So if we're going to get a flood of applications as we've been warned, then right now today, we got to staff up. I don't think that's right either. I'm also concerned about the expense. But just be clear what it is you're estimating, because the measure that was reported by the Fed committee has no standing. It hasn't passed.
Right.
You've got to estimate a change in policy against your current baseline, and the current baseline is conditional use.
Just a point of clarification, the current conditional use setback is 300 feet.
Right.
Right?
Right.
That would prohibit all service.
Exactly.
So you have to have a change to the current one. So if you want to measure the fiscal impact, it might be between the options. But what we have today is not a good baseline, because there's nothing that you could bring in at 300 feet.
That's right.
My point remains, you need to be clear before you do the estimate what it is you're measuring against.
Right. And so we're measuring against what we have in terms of a proposal of where we are with having all conditional use or some limited use for a large portion. I mean, I don't know what the portions would be, but I mean, and I'm not looking for exacts here, but I mean, is this going to mean additional, and I know you've looked at this, Mr. Russ, and I had a conversation with you before, so Mr. Leventhal, while I appreciate your delving into the specifics, I've already kind of briefed staff in terms of what questions I was going to ask. So from that perspective, Mr. Russ, if you could comment and just give me your thoughts and perspective on what the impacts might be on planning when it comes to evaluating this proposed conditional use for everything at this level of 60 feet.
For the record, Greg Russ from the Planning Board. From the standpoint of the limited use versus some being limited use and some being conditional use, clearly there would be many more conditional uses as a result of Councilmember Hucker's amendment, which also clearly would would mean the planning board staff would be reviewing many more of these, given the number of existing poles in neighborhoods that would be replaced or et cetera. So from that standpoint, whether we need more staff or not in terms of doing that, I can't comment on that specifically until we see the number of applications that actually come in. But I mean, just from a baseline standpoint, clearly, if a number of these, the taller ones, that the compatibility issues are minimized because they are already taller poles versus all of them going through the conditional use process, much larger impact to the planning board.
Ms. Schwartz-Jones?
Thank you, Councilmember Rice. So it is really difficult for me to sit here and tell you what the additional impact would be on DPS, but I would be remiss if I did not raise a serious concern about what this might do to the shot clock, and I think that my colleague Mitzi can better explain that. But keeping in mind that if something comes into OZA, and OZA's not here to speak to the impact on them, who would have the biggest burden of this, it would then have to go out for notice. It would then go over to the planning board, for the planning board to review, for the staff to write up packets, for various people to participate through the planning board and various agencies to participate through that process in order to get back over to OZA and get something scheduled for the fact-finding efforts that OZA would then undertake to make the findings it would need to make. From the DPS perspective, for us, there would be a bit more administration because we do administer the conditional uses and the processes that follow up on the conditional uses over time. So that would be a bit of an added burden. But, you know, we're going to, whether it's a limited use, which is, I think, more clear with the straightforward criteria versus the conditional use and the complaints that would result from the conditional uses that do require us to make investigations and reports back, you know, it would definitely have an impact, but I cannot tell you what that impact would be.
Ms. Nurmi or Ms. Rara, would you like to comment on your thoughts on this?
Sure. The reason why the county executive doesn't support this is because it would be quite a few, we estimate quite a few polls would have to go through this conditional use. As a result, right now, we did meet with the hearing examiner, and we were trying to actually look at if we could potentially batch the uses and if we could find some savings there. It turned out there